Hi, how you doing today? My name is Stuart Simone of Simone Legal, and I'm here to talk about something most of you have heard of, but few of you truly understand: living trusts. And I congratulate you for watching this video because it is smart to learn about living trusts. One thing I've noticed from doing many property title searches over the years is that the higher price the neighborhood, the higher the percentage of homes titled in living trusts. So, what is it that the wealthy and their expensive financial advisors have discovered about living trusts? Well, you already may know that having a living trust will keep your heirs from having to go through the miserable and expensive experience of a probate court case if you own real property. But did you know that trusts have many benefits to you while you're alive and kicking? So let's find out why having a living trust and holding your real estate in a living trust is such a wise strategy. In this video, you'll learn about trusts in general, living trusts in particular, and I'll show you no less than 10 ways that having an estate plan featuring a living trust can be a huge benefit to you and your family. Who should have a living trust? Now, I firmly believe from the bottom of my heart that every adult who owns at least one improved property should have a living trust. Why? Well, for one thing, I've personally had to go through probate as an attorney and as a beneficiary, so I can tell you from experience that it is a full-blown court proceeding that can take well over a year with a number of court hearings and a huge hassle for the personal representative, and where tens of thousands of dollars from the estate will be given to the probate attorney. So let's get more specific about who needs a living trust. If you live in California and check off one or more of the following, then you should have a living trust. Number one, you own real estate anywhere in the USA totaling over $184,500 as of 2023, and it increases every 3 years. Two, you have heirs, in other words, children, grandchildren, or other family members or close friends. Three, get bonus points if you are single, as you have no spouse to automatically inherit your estate. Number four, you get more bonus points if you own real estate in multiple states, as your heirs would need to open a separate probate case in each state that you own property. Okay, now that you know you need one, what is a trust? Now, people ask me all the time, what is a trust? Now, I could give you a legal definition, but I like to compare it to something most people already know about: a corporation. So trust documents are like corporate documents in that they are legal entities created by contract law that have certain elements. The grantor of the trust is like the founder of the company. Trustee is like the CEO or president of a corporation. That's the person who runs the show. The beneficiaries of the trust are like the stockholders or shareholders of the corporation, and as the name implies, are the ones who benefit or stand to benefit from the operation of the trust. So, what exactly is a living trust? Well, first off, let me point out that the words living trust is not a legal term, but is a marketing name. Legal term is revocable trust. It's a trust for the living as well. Now, unlike a will, which only becomes effective upon your death, a living trust is established and operative during your lifetime. So it not only determines how your assets are distributed after you pass away, but also has a number of benefits for you while you're alive and kicking. So that's the living part. Now, as the grantor, you establish the trust and transfer your property and assets into it. You choose the beneficiaries who will eventually receive the trust's assets in whatever manner you see fit. You also appoint a trustee to manage the trust and one or more successor trustees who become the new CEO after you pass. You, the grantor, determine the powers of the trustee. Some people just say, hey, whatever the trustee decides to do, which is called a discretionary trust, while other grantors spell out what happens to every single piece of property in the estate in great detail. It can get as complicated as you like, as simple as you like, and in a complete estate plan, you can also appoint guardians for minor children and provide for kids and adults with special needs. Now, the interesting and unique thing about the living trust is that you and your spouse or partner, if you decide to do it jointly, are the grantor, the trustee, and, while you're alive, the beneficiary. Now, speaking of jointly, the most common living trust is with a couple, typically married, and the two partners are the co-grantors and co-trustees. The joint trust is still living until the second spouse or partner passes away. Once the last grantor passes away, the trust immediately becomes irrevocable, meaning it cannot be changed. And the first successor trustee now becomes the trustee, who is legally obligated to follow the instructions that you made when we created the estate plan. As I mentioned a moment ago, some people give this new new trustee very specific and detailed instructions, while others give the acting trustee full discretion to use their best judgment. And if you have minor children when you pass, a guardian that you nominated in your estate plan now becomes the new parent of the children. This avoids any potential family disagreements, and I feel is very important. Revocable versus irrevocable trusts. You may have heard that there are two types of trusts: revocable trusts, grantor trusts, and irrevocable trusts. While only two letters are different in their spelling, they are completely different legal entities, and they have different purposes. The living trust we're talking about here is a revocable trust, which is much more common than the irrevocable variety. Although the legal term is revocable trust, it really should be called amendable trust, in my opinion, as people rarely revoke them, but often make changes, or what we call amendments, to them over time. The IRS calls it a grantor trust because you, the grantor, have full control over it. You can easily transfer assets to and from the revocable trust, amend it, or even terminate or revoke the trust. On the other hand, the whole point of having an irrevocable trust is that you have no control over it. And in fact, the assets that you place into an irrevocable trust are no longer legally owned by you. They are controlled by the trustee, who in this case is somebody other than yourself. In my opinion, irrevocable trusts should rarely be used, as irrevocable means forever. And once they're created, you can't change your mind. They are commonly used for elderly, wealthy people to get out of the federal estate tax, and that tax doesn't really apply to anybody with less than an estate worth $12.92 million as of 2023. In fact, only 0.04% of estates paid that tax since the threshold was raised by the Tax Cuts and Jobs Act of 2018. And by the way, in 2026, the estate tax might kick in at a lower amount if the bill is not renewed. Now, the other group who use irrevocable trusts are those interested in true asset protection. In other words, people who are expecting to be sued or perhaps contemplating a nasty divorce. Now, the property in an irrevocable trust is safe from creditors because, as I stated above, although you can enjoy its use, you legally don't own it anymore. Note, revocable living trust distributions are typically not taxable as they are considered gifts and not income, but irrevocable trust distributions could well be subject to taxation depending on who receives them and how much they receive. So, anyone considering an irrevocable trust should talk to their CPA, financial advisor, and probably a business attorney as well. Now, if asset protection is your primary concern, there are other less drastic ways to shield your property from potential creditors, such as land trusts. Now, with a land trust, you would have each property in its own land trust, and like an irrevocable trust, the trustee of the land trust is a third party. However, that's where the similarities end, as one, the land trust is revocable and amendable, and two, the trustee is obligated to follow your directions and instructions. If you're interested, I'll be talking about land trusts in another video. I've also made a video about owning properties in an LLC that in turn is owned by your living trust, which is a budget-friendly and efficient way to gain asset protection and estate planning. Check out that video. 10 benefits of living trusts. Now that we understand what a living trust is, let's explore the benefits that make it such an attractive option for many individuals and families. Why I believe it's a no-brainer for anyone who owns real estate. Benefit 1, avoiding probate. Now here's something to remember. A will should be called a will not, because a will alone will not keep your heirs from having to suffer through the probate process if you own property. One of the biggest advantages of a living trust is that it allows your heirs to avoid having to hire an attorney and go to court, go through the whole probate process. When you title your assets in the name of the trust, they are no longer considered part of your probate estate. This means that your beneficiaries can receive these assets quickly after you pass away without having to slog through a lengthy probate court case. So, what is the magic that allows this to happen? Well, if your property is owned by the Smart Family Living Trust while you're alive, who owns it after you die? That's right, the Smart Family Living Trust still owns the property. So there wasn't a transfer of title, as the only change is the trustee. That's the magic. And from almost any standpoint, especially regarding taxes, a transfer of property is not a good thing. Avoiding probate is an even bigger deal if you own property in multiple states. Did you know that if you passed away without proper estate planning, a separate court case would need to be opened in every state where you own real estate? Now, if you're a buy and hold investor with properties around the country, that means your heirs would have to file multiple cases and hire multiple attorneys in multiple states. No bueno. Benefit number 2, maintaining control and flexibility with a living trust. You retain maximum control and flexibility over your assets with a living trust. You can make changes to the trust throughout your life to accommodate new plans or beneficiaries. This document allows you to ensure that your intentions with estate planning are plainly evident, making it very challenging for disgruntled family members to contest the trust. In fact, we put in a no contest clause to strongly discourage that. A living trust is the vehicle that allows you to literally have control from beyond the grave. But if your heirs had to open a probate case, then you and they have lost control, as a judge becomes the one who decides what happens. You don't want that. All right, benefit number 3, customized asset distribution. A living trust allows you to determine precisely how your assets are distributed. Surely what the trust can do is only limited by your imagination, as long as it's legal. Whether you want your beneficiary or beneficiaries to retain a certain amount of income per month or have specific conditions for asset distribution, such as graduating from college, a living trust ensures that your wishes are granted. You can decide what percentages or what property each beneficiary receives and how things are distributed if one or more of them pass away before you do. All possibilities are considered in a good estate plan. All right, benefit number 4, privacy and confidentiality. Privacy is a crucial aspect of estate planning for many individuals. While a will becomes part of the public record when the probate case opens, a living trust remains a private document. The trust's details, including the identity of the beneficiaries and the distribution of assets, are not accessible to the public. This privacy allows you to maintain confidentiality within your family and ensures that your plans are not open to scrutiny or potential challenges. You instruct your successor trustee what to do, and after you're gone, he or she handles it as a private matter. Benefit number 5, tax benefits. Heirs don't pay taxes on living trust distributions in California. I've counseled many people who wanted to put one or more family members on title while they were alive. I always have to remind them that the state and federal laws are always favorable to property transfers at death and penalize those who make inter vivos transfers, even to their kids. Always keep in mind this general rule: inheriting is good. Now let's talk about capital gains tax, which is federal and state. Beneficiaries can save big on federal and state capital gains tax if they inherit the property. But what if you want to transfer title of your home to your beneficiary now, during your lifetime, inter vivos? If you put them on title now, you transfer your current tax basis to them, which is the price that you purchased the property for. So they would have to pay capital gains tax on the difference between what you originally paid for the property and what it's worth whenever they sell it, which could be a huge amount if you've owned the property for a long time. In fact, they could pay a massive tax even if they sold it immediately after you passed. On the other hand, you place your property in your living trust and have them receive the property when you pass away, then your heir or heirs will get a new stepped up tax basis to the current market value at the time of your passing. And if they sold the property right at that time, they pay 0 capital gains tax. How about that? Eventually, when they do sell it, the capital gains tax would be much lower because the starting point will be the fair market value when they inherited it, not the price that you had purchased it for years ago. Also, you won't have to worry if they get into an accident, file for bankruptcy, or have an IRS audit while you're alive, since they won't yet be on the title to your property. Now, B, property tax, state and county. Your heirs would also save big on property tax reassessment, especially for California properties. If you transfer your property while you're alive, in most cases, the property will be reassessed to its current fair market value. Now, thanks to California's unique property tax scheme, due to Proposition 13, your property tax bill could increase drastically if you've owned the house for a long time. Remember, Proposition 13 drastically limited the amount that your property taxes can rise each year. So, if you've owned the property a long time, you actually are paying a much less property tax than you would have otherwise. Now, post Proposition 19, children and grandchildren can avoid this reassessment, but only if they live and continue to live in the property as their primary residence. Otherwise, the person you are making an inter vivos gift to would be saddled with a much larger property tax bill than you are paying. Nasty. Benefit 6, financial protection for your heirs. Living trusts also have a special benefit to the heirs of a Californian's estate. Did you know that if you end up having major medical bills at the end of your life, as many people do who have long treatments for cancer and other terminal diseases, that your medical bills can be recovered by the state from your estate when you pass away. In other words, if you leave your loved ones a $1 million house free and clear, and you have $1 million in medical bills, your heirs would be forced to sell your house and your loved ones would get nothing. That's a big deal. Under state law, and this is true in most states, Medicare and Medicaid, Medi-Cal, or whatever it's called in your state, bills must be paid from the estate. Now, as California HCS website states, the Medi-Cal program must seek repayment from the estates of certain deceased Medi-Cal beneficiaries. Repayment only applies to benefits received by these beneficiaries on or after their 55th birthday and who own assets at the time of their death. When you receive our claim amount and are ready to submit payment, we accept electronic fund transfers, EFT, and checks. Now that's a message that nobody wants to receive. But wait, there's more. And this is good news for Californians. For Medi-Cal members who died on or after January 1st, 2017 due to SB 833, repayment will be limited only to estate assets subject to probate that were owned by the deceased beneficiary at the time of death. So if you have a living trust, your heirs are not subject to probate, and they are not subject to paying for your unpaid medical expenses. Woohoo! Benefit 7, cost savings for California investors. As I mentioned earlier, many California real estate investors have LLCs or some form of corporation. Many national real estate investing gurus advise buy and hold investors to form a separate LLC for every single property, which does afford some asset protection. But did you know that if your California business entity has $0 in transactions for the year, that the tax bill for that entity is still $800? Okay, so maybe you knew that. So you just go ahead and open a Nevada or Wyoming LLC to avoid that. Well, guess what? If the California Franchise Tax Board determines that you are a California resident, then they will bill you $800 per entity no matter where your LLCs or your properties are located. If you have 5 LLCs, that's a $4,000 state tax bill for starters. Yikes! Compare that to a living trust or land trust, which costs you nothing. So putting your properties in your trust can save you real money every year if you're budget conscious. Benefit number 8, business advantages. What if you already have an LLC? Well, you can assign the LLC to your living trust, which won't save you the $800 per year, but would give you some added asset protection and keep the business moving when you pass away. When a partner in your business passes away or becomes disabled, a revocable living trust can be an important tool in addressing concerns about succession of leadership and ownership. Remember that show, Succession? Must watch, by the way. Companies can find themselves in critical financial distress or out of business altogether due to estate taxes or other related hardships that result from the death of an owner or key partner. But a trust of this kind can appoint a successor trustee and instruct them to continue business operations. However, there are some complications to consider. A business owner cannot be both the sole beneficiary and trustee of the trust holding their business, which means they would need to involve family members, spouses, or a third party as beneficiaries or trustees. This can raise concerns in the case of divorce or add costs for hiring a third-party trustee. On the other hand, there are no issues if you are the typical living trust client who has family or friend beneficiaries and if married a co-trustee. You might want to consult with an experienced business attorney and/or business CPA to determine if having your trust own your business entity is the right setup for you. Now, benefit number 9, children from prior marriages. In the modern world, people live longer lives and have more marriages than in previous generations. That's a fact. This makes it increasingly likely for legal disputes over assets to occur between spouses and children from different chapters of a family's history. A second spouse may want to shut out biological children from a first marriage. Now, a revocable living trust can spell out the boundaries within which the surviving spouse must act, limit their control of the trust, prevent them from disinheriting children or entities from the first marriage, and move certain assets into a separate trust solely controlled by the biological parent. Typical living trust for a blended family would have a distribution to the beneficiaries at the death of the first spouse as well as the second. Benefit number 10, personal or beneficiary disabilities. Revocable living trust is an ideal way to keep assets under your control even if you become mentally or physically unable to manage them. In addition, it can protect the trust to beneficiaries with disabilities from losing supplemental security income or SSI benefits. Under current federal rules, SSI recipients can be disqualified from receiving benefits if they come into an inheritance. Even if they disclaim the inheritance, they may still be hit with a significant penalty depending on the value of their share. A carefully crafted document can avoid this issue with the inclusion of a special needs trust, which allows the individual with special needs to receive the inheritance in a separate account earmarked for non-Medicaid use. They will then continue to collect SSI benefits in support of their disability. A living trust can also address future plans for disabled adults living in the home should the grantor pass away, typically with a provision that provides a lifetime interest in estate assets for those individuals. So, in conclusion, determining whether a living trust is right for you is a personal decision based on your unique circumstances and goals. However, the benefits of a living trust, such as maintaining control and flexibility, customizing asset distribution, preserving privacy, gaining tax advantages, and saving money, do make it an appealing option for many. If you're considering setting up a living trust, we highly recommend consulting with an experienced estate planning attorney, especially one knowledgeable in California laws. They can guide you through the process, ensure all your legal documents are in order, and help you create a comprehensive estate plan. Now, I happen to know a great estate planning attorney. Oh, that'd be me! So, for more information or if you have questions, call Simone Legal at 8339-SIMONE or schedule a free consultation right now. Our comprehensive living trust package features a 20-page living trust and also includes a certificate of trust, pour-over will, durable power of attorney, HIPAA waiver, advanced health care directive, final arrangement section, and the deeds you will need to fund the trust. It offers numerous benefits during one's lifetime, such as enabling the people you choose to make medical and financial decisions and giving them access to your medical records if you ever became legally incapacitated. And of course, it ensures a smooth transition after passing, preventing family disputes and providing guidance on funeral arrangements and asset distribution. Your family will be grateful. But thank you for watching this entire video. I hope you learned a lot, and I would love to hear from you. Have a great day.